Judicial Department. Judicial power, defined, includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Section 1, Paragraph 2, Article 8. Letter A. The second clause effectively limits the political question area which heretofore was forbidden territory for the courts. B. The inherent powers of a court to amend and control its processes and orders so as to make them conformable with law and justice includes the right to reverse itself, especially when, in its honest opinion, it has committed an error or mistake in judgment, and that to adhere to its decision will cause injustice to a party litigant. Takao v. Court of Appeals, GR number 127405, September 20, 2001. The court is not precluded from examining its own ruling and rectifying errors of judgment if blind and stubborn adherence to res judicata would involve the sacrifice of justice to technicality. De Leon v. Court of Appeals. Number 2. Where vested in one Supreme Court and in such lower courts as may be established by law. Section 1, Article 8. Jurisdiction. Jurisdiction is defined as the power to hear and decide a case. Letter A. Congress shall have the power to define, prescribe, and apportion the jurisdiction of the various courts, but may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5, Article 8, Section 2, Article 8. B. No law shall be passed increasing the appellate jurisdiction of the Supreme Court as provided in the Constitution without its advice and concurrence. Section 30, Article 6. Thus, Section 27, RA 6770, which authorizes an appeal to the Supreme Court from decisions of the Ombudsman in administrative disciplinary cases, was declared unconstitutional because the provision was passed without the advice and consent of the Supreme Court. Fabian v. Desierto. Constitutional safeguards to ensure the independence of the judiciary. 1. The Supreme Court is a constitutional body and may not be abolished by the legislature. 2. The members of the Supreme Court are removable only by impeachment. 3. The Supreme Court may not be deprived of its minimum original and appellate jurisdiction. Appellate jurisdiction may not be increased without its advice and concurrence. 4. The Supreme Court has administrative supervision over all inferior courts and personnel. 5. The Supreme Court has the exclusive power to discipline justices of inferior courts. 6. The members of the judiciary have security of tenure. 7. The members of the judiciary may not be designated to any agency performing quasi-judicial or administrative functions. 8. Salaries of judges may not be reduced. The judiciary enjoys fiscal autonomy. Letter A. In re clarifying and strengthening the organization, structure, and administrative setup of the Philippine Judiciary Academy, AM number 01104 SC, Filja, the Supreme Court said that the fiscal autonomy enjoyed by the judiciary contemplates a guarantee of full flexibility to allocate and utilize the resources with the wisdom and dispatch that their needs require. It recognizes the power and authority to levy, assess, and collect fees, fixed rates of compensation, not exceeding the highest rates authorized by law for compensation and pay plans of the government, and allocate and disperse such sums as may be provided by law or prescribed by them in the course of the discharge of their functions. In downgrading the positions and salary grades of 2 positions in the Philippine Judicial Academy, the DBM overstepped its authority and encroached upon the fiscal autonomy of the Supreme Court and its power of supervision over court personnel as enshrined in the Constitution. Number 9. The Supreme Court alone may initiate and promulgate the rules of court. Number 10. The Supreme Court alone may order temporary detail of judges. 11. The Supreme Court can appoint all officials and employees of the judiciary. Letter C. The power of judicial review or inquiry. D. Appointment to the judiciary. Number 1. Qualifications of proven competence, integrity, probity, and independence. Section 7. Number 3. Article 8. In addition, Supreme Court, natural-born citizen of the Philippines at least 40 years of age for 15 years or more, a judge of a lower court or engaged in the practice of law in the Philippines. B. Lower collegiate courts, natural-born citizens of the Philippines, member of the Philippine Bar, but Congress may prescribe other qualifications. C. Lower courts, citizen of the Philippines, member of the Philippine Bar, but Congress may prescribe other qualifications. Number 2. Procedure for appointment. Appointed by the President of the Philippines from among a list of at least 3 nominees prepared by the Judicial and Bar Council. For every vacancy, the appointment shall need no confirmation. Letter B. Any vacancy in the Supreme Court shall be filled within 90 days from the occurrence thereof. C. For lower courts, the President shall issue the appointment within 90 days from the submission of the JBC of such list. Relate this to the constitutional prohibition against midnight appointments, Section 15, Article 7, which states that 2 months immediately before the next presidential elections and up to the end of his term, a president or acting president shall not make appointments, except temporary appointments, to executive positions when continued vacancies therein will prejudice public service or endanger public safety. In re Mateo Valenzuela. It was held that during this period, when appointments are prohibited, the President is not required to make appointments to the courts nor allowed to do so, while the filing up of vacancies in the judiciary is in the interest of the public. There is no showing in this case of any compelling reason to justify the issuance of the appointment during the period of the ban. 3. The Judicial and Bar Council. Composition. Ex officio members. Chief Justice as Chairman, the Secretary of Justice as a representative of Congress. Regular members, a representative of the Integrated Bar of the Philippines, a professor of law, a retired justice of the Supreme Court, and a representative of the private sector. Secretary ex officio, the clerk of the Supreme Court. Appointment. The regular members shall be appointed by the President for a term of 4 years. With the consent of the Commission on Appointments, they shall receive such emoluments as may be determined by the Supreme Court. Powers or functions. Principal function of recommending appointees to the judiciary may exercise such other functions and duties as the Supreme Court may assign to it. The Supreme Court. Composition. Chief Justice and 14 associate justices. It may sit en banc or in its discretion in division of 3, 5, or 7 members. Any vacancy shall be filled within 90 days from the occurrence thereof. Number 2. En banc or division cases. En banc. All cases involving the constitutionality of a treaty, international or executive agreement, or law, and all other cases which, under the rules of court, are to be heard en banc, including those involving the constitutionality, application or operation of presidential decrees, proclamations, orders, instructions, ordinances, and other regulations. These cases are decided with the concurrence of a majority of the members who actually took part in the deliberation on the issue and voted thereon. B. Division. Other cases or matters may be heard in division and decided or resolved with the concurrence of a majority of the members who actually took part in the deliberation on the issues and voted thereon, but in no case without the concurrence of at least 3 such members. When the required number is not obtained, the case shall be decided en banc. In Fortich v. Corona, August 19, 1999, the Supreme Court interpreted the provision by drawing a distinction between cases on the one hand and matters on the other hand, such that cases are decided while matters are resolved. On the basis of this distinction, only cases are referred to the Supreme Court en banc for decision whenever the required number of votes is not obtained. No doctrine or principle of law laid down by the court in a decision rendered en banc or in division may be modified or reversed except by the court sitting en banc. The reorganization of the 3 divisions of the court is purely an internal matter in which the petitioner has no business at all. With its new membership, the court is not obliged to follow blindly a decision upholding a party's case when after its re-examination the rectification appears proper and necessary. Limketsky Sans Miling versus Court of Appeals. Powers. Section 5, Article 8. Original jurisdiction over cases affecting ambassadors, other public ministers and consuls, and over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. Appellate jurisdiction. Review, revise, reverse, modify, or affirm on the appeal or certiorari as the law or rules of court may provide, final judgments and orders of lower court in all cases in which the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. All cases involving the legality of any tax, impost, assessment, or toll, or any penalty imposed in relation thereto. All cases in which the jurisdiction of any lower court is in issue. All criminal cases in which the penalty imposed is reclusion perpetua or higher, and all cases in which only an error or a question of law is involved. Note that this power does not include the power of the Supreme Court to review decisions of administrative bodies, but is limited to final judgments and orders of lower courts. Rufy versus Chief of Staff. Only in cases where the penalty actually imposed is death must the trial court forward their records to the case to the Supreme Court for automatic review of the conviction. People versus Reduloso. Where the penalty imposed is merely reclusion perpetua, the accused should appeal the decision of conviction. Otherwise, the judgment of conviction will become final and executory. Garcia versus People. Section 30, Article 6 provides that no law shall be passed increasing the appellate jurisdiction of the Supreme Court without its concurrence. Thus, in Fabian versus Desierto, which provides that orders, directives, and decisions of the Ombudsman in administrative cases are appealable to the Supreme Court through Rule 45 of the Rules of Court, was declared unconstitutional because it expands the Supreme Court's jurisdiction without its advice and concurrence. See also Namuhe versus Ombudsman. In Republic versus Sandigan Bayan, it was held that the appellate jurisdiction of the Supreme Court over decisions and final orders of the Sandigan Bayan is limited to questions of law. A question of law exists when the doubt or controversy concerns the correct application of law or jurisprudence to a certain set of facts, or when the issue does not call for an examination of the probative value of the evidence presented, the truth or falsehood of facts being admitted. Temporary assignment of judges. Temporary assignment of judges of lower courts to other stations as public interests may require, but the assignment shall not exceed 6 months without the consent of the judge concerned. Order change of venue or place of trial to avoid miscarriage of justice. Rulemaking power. Promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. Limitations on the rulemaking power. The rules must provide a simplified and inexpensive procedure for the speedy disposition of cases. They must be uniform for all courts of the same grade and must not diminish, increase, or modify substantive rights. See Primicias versus Ocampo, which is authority for the principle that trial by assessor is a substantive right and may not be repealed by the Supreme Court. Likewise, in First Lepantos Ceramics versus Court of Appeals, it was held that Supreme Court Circular No. 1-91, which orders that appeals from decisions of administrative bodies shall now be filed with the Court of Appeals, did not repeal EO 226 and did not diminish, increase, or modify the substantive right to appeal. It merely transferred the venue of appeals from decisions of said agencies to the Court of Appeals, and provided a different period, 15 days from notice, both of which are merely procedural in character. In request for creation of a special division, it was held that it is within the competence of the Supreme Court, in the exercise of its power to promulgate rules governing the enforcement and protection of constitutional rights, and rules governing pleading, practice, and procedure in all courts, to create a special division in the Sandigan Bayan, which will hear and decide the plunder case against former President Joseph Estrada. An integrated bar is a state-organized bar to which every lawyer must belong, as distinguished from a bar association organized by individual lawyers themselves, membership in which is voluntary. Integration of the bar is essentially a process by which every member of the bar is afforded an opportunity to do his share in carrying out the objectives of the bar as well as obliged to bear his portion of its responsibilities. The integration of the Philippine bar means the official unification of the entire lawyer population. This requires membership and financial support of every attorney as condition sine qua non to the practice of law and the retention of his name in the roll of attorneys of the Supreme Court. In re integration of the bar of the Philippines, 49 Squat 22. Thus, payment of dues is a necessary consequence of membership in the integrated bar of the Philippines, of which no one is exempt. This means that the compulsory nature of payment of dues subsists for as long as one's membership is in the IBP remains regardless of the lack of practice of or the type of practice the member is engaged in. Letter of Attorney Cecilio V. Y. Arevalo, Jr., requesting exemption from payment of IBP dues. The enforcement of the penalty of removal does not amount to deprivation of property without due process of law. The practice of law is not a property right but a mere privilege, and as such must bow to the inherent regulatory power of the Supreme Court to exact compliance with the lawyer's public responsibilities. In re Attorney Marshall Edilon. The writ of amparo. The nature and time-tested role of amparo has shown that it is an effective and inexpensive instrument for the protection of constitutional rights. As Cunha, the writ of amparo. Literary, to protect, originated in Mexico and spread throughout the Western Hemisphere, where it gradually evolved into various forms depending on the particular needs of each country. By resolution in AM number 07912 SC, the Supreme Court promulgated the rule on the writ of amparo, and it took effect on October 24, 2007. Section 1 thereof provides, the petition for a writ of amparo is a remedy available to any person whose right to life, liberty, and security is violated or threatened with violation by an unlawful act or omission of a public official or employee or of a private individual or entity. An extraordinary feature in Section 14 of the rule, which allows the grant by the court of interim relief, which may either be a temporary protection order, inspection order, production order, or a witness protection order. No writ of amparo may be issued unless there is a clear allegation of the supposed factual and legal basis of the right sought to be protected. Petitioners' right to their dwelling, assuming they still have any despite the final executory judgment adverse to them, does not constitute right to life, liberty, and security. There is therefore no legal basis for the issuance of the writ of amparo. Canlas versus Napico Homeowners Association, GR number 182795. The writ of amparo shall not issue when applied for as a substitute for the appeal of certiorari process, or when it will inordinately interfere with these processes. Tapos versus Del Rosario. The writ of habeas data. The writ of habeas data is an independent remedy to protect the right to privacy, especially the right to information privacy. The essence of the constitutional right to informational privacy goes to the very heart of a person's individuality, an exclusive and personal sphere upon which the state has no right to intrude without any legitimate public concern. The basic attribute of an effective right to informational privacy is the right of the individual to control the flow of information concerning or describing them. By resolution in AM number 08116 SC, the Supreme Court promulgated the rule on the writ of habeas data effective February 2, 2008. Section 1 thereof provides, the writ of habeas data is a remedy available to any person whose right to privacy in life, liberty, or security is violated or threatened with violation of an unlawful act or omission of a public official or employee, or of a private individual or entity engaged in the gathering, collecting, or storing of data or information regarding the person, family, owner, and correspondence of the aggrieved party. Congress cannot amend the rules of court. In Echegaray v. Secretary of Justice, the Supreme Court declared, but most importantly, the 1987 Constitution took away the power of Congress to repeal, alter, or supplement rules concerning pleading, practice, and procedure. In fine, the power to promulgate rules of pleading, practice, and procedure is no longer shared by this court with Congress, more so with the executive. Rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. Power of appointment. The Supreme Court appoints all officials and employees of the judiciary in accordance with the civil service law. Power of administrative supervision. The Supreme Court shall have administrative supervision over all courts and the personnel thereof. The Ombudsman may not initiate or investigate a criminal or administrative complaint before his office against a judge. He must first endorse the case to the Supreme Court for appropriate action. Fuentes versus Office of the Ombudsman, Mindanao. In the absence of any administrative action taken against the RTC judge by the Supreme Court with regard to the former certificate of service, the investigation conducted by the Ombudsman encroaches into the Supreme Court's power of administrative supervision over all courts and its personnel, in violation of the doctrine of separation of powers, Macera versus Vasquez. The administrative proceedings before the Supreme Court are confidential in nature in order to protect the respondent therein, who may turn out to be innocent of the charges. It can take years to build a reputation, and only a single accusation, although unfounded, to destroy it. Godinez versus Alano. Annual Report. Supreme Court to submit within 30 days from the opening of each regular session of Congress to the President and to Congress an annual report of the operations and activities of the judiciary. Consultations, decisions of Supreme Court. Conclusions in any case submitted to it for decision shall be reached in consultation before the case is assigned to a member for the writing of the opinion of the court. A certification to this effect signed by the Chief Justice shall be issued. This requirement is applicable also to lower collegiate courts. But this requirement does not apply to administrative cases, Prudential Bank versus Castro. When the votes are equally divided and the majority vote is not obtained, then pursuant to Section 7, Rule 56 of the Rules of Civil Procedure, the petition shall be dismissed. Cruz versus Secretary of DNR. The decision shall state clearly and distinctly the facts and the law on which it is based. But this requirement does not apply to a minute resolution dismissing a petition for habeas corpus, certiorari, and mandamus, provided a legal basis is given therein. Mendoza versus CFI. Neither will it apply to administrative cases, Prudential Bank versus Castro. This constitutional mandate does not preclude the validity of memorandum decisions, which adopt by reference the findings of fact and conclusion of law contained in the decisions of inferior tribunals. Memorandum decisions are a species of succinctly written decision by appellate courts in accordance with the provision of Section 14 BP 129 as amended, on the grounds of expediency, practicality, convenience, and docket status of our courts. But to be valid, it cannot incorporate the findings of fact and the conclusions of law of the lower court only by means of remote reference, which is to say that the challenged decision is not easily and immediately available to the person reading the memorandum decision. For the incorporation by reference to be allowed, it must provide for direct access to the facts and the law being adopted, which must be contained in a statement attached to the said decision. In other words, the memorandum decision should actually embody the findings of facts and conclusions of law of the lower court in an annex attached to and made an indispensable part of the decision. A decision need not be complete recital of the evidence presented, so long as the factual and legal basis are clearly and distinctly set forth supporting the conclusions drawn therefrom. The decision arrived at is valid. However, it is imperative that the decision not simply be limited to the dispositive portion, but must state the nature of the case, summarize the facts with reference to the record, and contain a statement of applicable laws and jurisprudence, and the tribunal's statement on conclusions of the case. Thus, in Dizon versus Judge Lopez, the decision which consisted only the dispositive portion, denominated as in per juicio judgment, was held invalid. In People versus Baring, GR 137933, the Supreme Court said that the trial court's decision may cast doubt on the guilt of the accused, not by the lack of direct evidence against the accused, but by the trial court's failure to fully explain the correlation of the facts. The weight of admissibility of the evidence, the assessment made from the evidence, and the conclusion drawn therefrom, after applying the pertinent law as basis of the decision. Likewise in the Vera versus Judge Dames, because the respondent judge had precipitately concluded that the letter was defamatory without sufficiently explaining why, he was deemed to have violated Section 14, Article 8, and although there was no clear proof of malice, corrupt motives, or improper consideration, the judge must still be sanctioned. No petition for review or motion for reconsideration shall be refused due to course or denied without stating the legal basis thereof. In Father Martinez versus Court of Appeals, the Court of Appeals denied the petitioner's motion for reconsideration in this wise. Evidently, the motion poses nothing new. The points and arguments raised by the movants have been considered and passed upon in the decision sought to be reconsidered. Thus, we find no reason to disturb the same. The Supreme Court held that there was adequate compliance with the constitutional provision. In Prudential Bank versus Castro, the Supreme Court ruled that lack of merit is sufficient declaration of the legal basis for denial of petition for review or motion for reconsideration. In Komatsu Industries versus Court of Appeals, it was held that when the court, after deliberating on a petition and any subsequent pleadings, manifestations, comments, or motions, decide to deny due course to a petition and states, in a minute resolution, that the questions raised are factual or no reversible error in the respondent court's decision is shown or some other legal basis stated in the resolution, there is sufficient compliance with the constitutional requirement. This is reiterated in Tichanco versus Enriquez 150629, Tenure of Judges or Justices. Supreme Court, Justices may be removed only by impeachment. In rare first endorsement from Honorable Raul M. Gonzalez, April 15, 1988, the Supreme Court said that the Special Prosecutor, Tanul Bayan, is without authority to conduct an investigation on charges against a member of the Supreme Court with the end in view of filing a criminal information against him with the Sandigan Bayan. This is so because if convicted in the criminal case, the justice would be removed, and such removal would violate his security of tenure. Number 2. Lower courts. Judges shall hold office during good behavior until they reach the age of 70 years or become incapacitated to discharge the duties of their office. A. The Supreme Court and Bank shall have the power to discipline judges of lower courts or order their dismissal by a vote of a majority of the members who actually took part in the deliberation and the issue and voted thereon. In People versus Judge Gakot, it was held that the first clause in the said section is a declaration of the grant of the disciplinary power to and the determination of the procedure in the exercise thereof by the court and bank. It did not intend that all administrative disciplinary cases should be heard and decided by the whole court. The second clause, intentionally separated from the first by a comma, declares that the court and bank may order their dismissal by a vote of a majority. Thus, only cases involving dismissal of judges or lower courts are specifically required to be decided by the court and bank. In the absence of any administrative action taken against the RTC judge by the Supreme Court with regard to his certificate of service, the investigation being conducted by the Ombudsman encroaches into the Supreme Court's power of administrative supervision over all courts and its personnel, in violation of the doctrine of separation of powers, Macera versus Vasquez. It was held that because in Judge Caobes versus Ombudsman, it was held that because of Section 6, Article 8, vesting in the Supreme Court exclusive administrative supervision over all courts and its personnel, the Ombudsman cannot determine for itself and by itself whether a criminal complaint against a judge or court employee involves an administrative matter. The Ombudsman is duty-bound to have all cases against judges and court personnel filed before it referred to the Supreme Court. In Office of the Judicial Administrator versus Pascual, The Supreme Court, reiterating Requisa versus Castaneda, declared that the grounds for the removal of a judicial officer should be established beyond reasonable doubt, particularly where the charges on which the removal is sought are misconduct in office, willful neglect, corruption, incompetence, etc. Thus, in De Vera versus Dames, the Supreme Court said that judges cannot be disciplined for every erroneous order or decision rendered in the absence of a clear showing of ill motive, malice, or bad faith. This, however, is not license for them to be negligent or abusive in performing their adjudicatory prerogatives. The absence of bad faith or malice will not totally exculpate them from charges of incompetence and ignorance of the law when they render decisions that are totally bereft of factual and legal basis. This was reiterated in Diet versus Judge Garcia, where the judge was nonetheless taken to task for issuing an order discrediting the period served by the prisoner outside the jail without giving the prisoner a chance to be heard, thus betraying his ignorance of the cardinal principle of due process. In the Guzman versus Judge Season, the Supreme Court said that the respondent had shamed the judiciary by deliberately applying not only patently inapplicable but also already repealed laws. The judge was dismissed from the service because, according to the court, when the law violated is elementary, the failure to know or observe it constitute gross ignorance of the law. In Spouses Antonio and Elsa Fortuna versus Judge Penacositaca, because the judge accepted at face value a mere machine copy of the bail bond issued by another court, the judge was subjected to administrative sanction because it is highly imperative that judges should be conversant with basic legal principles and be aware of well-settled authoritative doctrines. In Aguilan versus Judge Fernandez, for receiving the deposit of cash as bail and keeping the same in his office, the judge was held administratively liable even after the complainant executed an affidavit of desistance. However, in Re Derogatory News item charging Court of Appeals Associate Justice Demetria with interference on behalf of a suspected drug queen, the Supreme Court said that although every office in government service is a public trust, no position exacts a greater demand on moral righteousness and uprightness than a seat in the judiciary. High ethical principles and a sense of propriety should be maintained, without which the fate of the people in the judiciary, so indispensable in an orderly society, cannot be preserved. There is simply no place in the judiciary for those who cannot meet the exacting standards of judicial conduct and integrity. Similarly, in Re released by Judge Manuel T. Muro, where the judge, despite opposition from the prosecution, simply issued an order submitting for resolution the motion and the opposition without the same being heard, and later granting the motion for extension of medical confinement for 2 months, the Supreme Court found the judge guilty of gross misconduct for being utterly inefficient and for manifest partiality. And it is said that when the inefficiency springs from a failure to consider so basic and elemental a rule, a law, or a principle in the discharge of his duties, a judge is either too incompetent and undeserving of the position and title he holds, or he is too vicious that the oversight or omission was deliberately done in bad faith and in grave abuse of judicial authority. No law shall be passed reorganizing the judiciary when it undermines the security of tenure of its members. In De La Lana versus Alba, it was held that BP 129 was a valid reorganization law, and that therefore the abolition of then existing judicial offices did not violate security of tenure. Note, in view of the clear declaration of Section 2, Article 8, the ruling in De La Lana, as well as that in Ocampo versus Secretary of Justice, may be said to have been modified accordingly. Salaries fixed by law may not be decreased during their continuance in office. In Nita Fan versus Tan, it was held that imposition of income tax on salaries of judges does not violate the constitutional prohibition against decrease in salaries. Periods for decision. In case all cases filed after the effectivity of the Constitution must be decided or resolved from the date of submission within 24 months. Supreme Court 12 months. Lower collegiate courts 3 months, and all other lower courts, unless in the two latter cases the period is reduced by the Supreme Court, a certification to be signed by the Chief Justice or presiding justice shall be issued stating the reason for delay. While it is truly the duty of the judge to decide cases with good dispatch, he must not sacrifice for expediency's sake the fundamental requirements of due process, nor forget that he must conscientiously endeavor each time to seek the truth, to know and aptly apply the law, and to dispose of the controversy objectively and impartially, all to the end that justice is done to every party. Young versus Judge de Guzman. In Dizon versus Judge Lopez, September 5, 1997, respondent judge was held to have violated Section 15, Article 8, because although she promulgated her decision within 3 months from submission, only the dispositive portion was read at such promulgation, and it took 1 year and 8 months more before a copy of the complete decision was furnished to the complainant. What respondent did was to render a sin per juicio judgment, which is a judgment without a statement of the facts in support of its conclusions, to be later supplemented by the final judgment. As early as 1923, the Supreme Court already expressed its disapproval of the practice of rendering sin per juicio judgment. What should be promulgated must be the complete decision. Section 15, Article 8 is designed to prevent delay in the administration of justice, and judges are repeatedly reminded that failure to decide cases within the prescribed period is not excusable and constitutes gross inefficiency, which is a ground for administrative sanction against the defaulting judge. Report on the Judicial Audit in RTC Branch 27 of Lapu-Lapu City. The Supreme Court. Thus, in Sanchez versus Judge Vestil, the Supreme Court said that judges who cannot comply with this mandate should ask for additional time, explaining in the request the reasons for the delay. In Recalco versus Judge Camarista, the Supreme Court said that a judge cannot be allowed to blame her court personnel for her own incompetence or negligence. She ought to know the cases submitted to her for decision or resolution and is expected to keep her own record of cases so that she may act on them promptly. Neither does delay in the transcription of stenographic notes excuse such failure, nor do additional assignments or designations make him less liable for the delay. Gonzalez Decano versus Judge Stiapno. Despite expiration of the mandatory period, the court, without prejudice to such responsibility as may have been incurred in consequence thereof, shall decide or resolve the case or matter submitted to it without further delay. The court does not lose jurisdiction over the case despite the lapse of the mandatory period, but the erring judge or justice may be subjected to administrative sanctions for the delay. Interpreting a similar provision in the 1973 Constitution, in Marcelino versus Cruz, reiterated in New Frontier Mines NLR versus NLRC, the Supreme Court held that the provision is merely directory, being procedural in nature. However, in Bernardo versus Judge Fabros, the Supreme Court said that the failure of the judge to decide a case within the reglementary period constitute gross dereliction of duty, the gravity of which depends on several factors, including the number of cases not decided on time, the damage suffered by the parties as a result of the delay, and the presence of other aggravating or mitigating circumstances. Other cases where administrative sanctions were imposed by the Supreme Court on judges for failure to decide resolved cases, matters within the period prescribed in the Constitution. Prosecutor Robert Vispal versus Judge Ramos. What are these? Report Judge Arinday, respondent. Report on the judicial audit in the MTC of Calasiao, Binmali, Santa Barbara, and Papandan, and in the MTC of Tayug San Nicolas. In rare problem of delays in cases before the Sandigan Bayan. November 8, 2001, Sandigan Bayan Presiding Justice Francis Garchi Torrena was fined 20,000 and was relieved of his powers, function, and duties as presiding justice so that he may devote himself exclusively to decision writing. His motion for reconsideration was denied on January 31, 2002. Judicial Department composition. The Supreme Court and all lower courts make up the judicial department of our government. Common provisions. 1. Independence of judiciary, congressional oversight, separation of powers, general rules, period to decide case. Independence of judiciary, 2000 bar question. To maintain the independence of the judiciary, the following safeguards have been embodied in the Constitution. 1. The Supreme Court is a constitutional body. It cannot be abolished, nor may its membership or the manner of its meeting be changed by mere legislation. Article 8, Section 2. The members of the Supreme Court may not be removed except by impeachment. The Supreme Court may not be deprived of its minimum original and appellate jurisdiction as prescribed in Article 10, Section 5. Number 4. The appellate jurisdiction of the Supreme Court may not be increased by law without its advice or concurrence. Appointees to the judiciary are now nominated by the Judicial and Bar Council and no longer subject to confirmation by Commission on Appointments. Number 6. The Supreme Court now has administrative supervision over all lower courts and their personnel. The Supreme Court has exclusive power to discipline judges of lower courts. The members of the Supreme Court and all lower courts have security of tenure, which cannot be undermined by a law reorganizing the judiciary. They shall not be designated to any agency performing quasi-judicial or administrative functions. The salaries of judges may not be reduced during their continuance in office. The judiciary shall enjoy fiscal autonomy. Only the Supreme Court may order the temporary detail of judges. The Supreme Court can appoint all officials and employees of the judiciary. Section 3. The judiciary shall enjoy fiscal autonomy. Appropriations for the judiciary may not be reduced by the legislature below the amount appropriated for the previous year, and after approval shall be automatically and regularly released. Fiscal autonomy means freedom from outside control. As envisioned in the Constitution, fiscal autonomy enjoined by the judiciary contemplates a guarantee of full flexibility to allocate and utilize the resources with the wisdom and dispatch that their needs require. Fiscal autonomy recognizes the power and authority to a. Levy, assess, and collect fees, b. Fix rates of compensation not exceeding the highest rates authorized by law for compensation, and c. Pay plans for the government and allocate or disperse such sums as may be provided by law or prescribed by them in the course of the discharge of their functions. The imposition of restrictions and constraints on the manner the Supreme Court allocate and utilize the funds appropriated for their operations in anathema to fiscal autonomy and violative to the express mandate of the Constitution and of the independence and separation of powers. Bengtson versus Drillon. Reason: fiscal autonomy is granted to the Supreme Court to strengthen its autonomy. The provision is intended to remove courts from the mercy and caprice, not to say vindictiveness, of the legislature when it considers the General Appropriations Bill. Judicial power. Section 1. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack of or excess of jurisdiction on the part of any branch or instrumentality of the government. Judicial power where vested. Judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Section 1, Paragraph 1. Definition of judicial power. Traditional concept. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable. Broadened concept. Duty to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the party of any branch or instrumentality of the government. Section 1, second sentence. Scope of judicial power. Judicial power is the measure of the allowable scope of judicial action. The use of the word includes in Section 1 connotes that the provision is not intended to be an exhaustive list of what judicial power is. An accused who has been convicted by final judgment still possesses collateral rights, and these rights can be claimed in the appropriate courts. Example, death convict who becomes insane after his final conviction cannot be executed while in a state of insanity. The suspension of death sentence is an exercise of judicial power. It is not usurpation of the presidential power of reprieve through the effect, though the effect is the same, the temporary suspension of the execution of the death convict. The issuance of subsequent resolutions by the court is simply an exercise of judicial power under Article 8 of the Constitution, because the execution of the decision is but an integral part of the adjudicative function of the court. It is clear that the final judgment includes not only what appears upon its face to have been so adjudged, but also those matters actually and necessarily included therein or necessary thereto. Certainly, any activity that is needed to fully implement a final judgment is necessarily encompassed by said judgment. MMDA versus Concerned Citizens of Manila Bay. Limit on judicial power. Courts may assume to perform non-judicial functions. It is not the function of the judiciary to give advisory opinion. Judicial power must sometimes yield to separation of powers, political questions, and enrolled bill rule. By the principle of separation of powers, courts may neither attempt to assume nor be compelled to perform non-judicial functions. Thus, a court may not be required to act as board of arbitrators, Manila Electric Company versus Pasay Transportation, nor may it be charged with administrative functions except when reasonably incidental to the fulfillment of official duties. Neither is it the function of the judiciary to give advisory opinions. Advisory opinions is an opinion issued by a court that does not have the effect of resolving a specific legal case, but merely advises on the constitutionality or interpretation of law. The nature of judicial power is also the foundation of the principle that it is not the function of the judiciary to give advisory opinions. If the courts will concern itself with the making of advisory opinions, there will be loss of judicial prestige. There may be less than full respect for court decisions. Declaratory judgment versus advisory opinions. Declaratory judgment involves real parties with real conflicting interests. Judgment is a final one, forever binding on the parties, a judicial act. Advisory opinions responds to a legal issue posed in the abstract in advance of any actual case in which it may be presented, binds no one, not a judicial act. The broadened concept of judicial power is not meant to do away with the political questions doctrine itself. The concept must sometimes yield to separation of powers, to the doctrine of political questions, or to the enrolled bill rule. Grave abuse clause. To determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Not every abuse of discretion can be the occasion for the court to come in by virtue of the second sentence of Section 1. It must be grave abuse of discretion amounting to lack or excess of jurisdiction. There is grave abuse of discretion when an act done contrary to the Constitution, the law, or jurisprudence, or it is executed whimsically, capriciously, arbitrarily, out of malice, ill will, or personal bias. Infotech versus Comelec. Again, the broadened concept of judicial power is not meant to do away with the political questions doctrine itself. The concept must sometimes yield to separation of powers, to the doctrine on political questions, or to the enrolled bill rule. Rule 65 embodies the grave abuse clause. Role of legislature in judicial process. Although judicial power is vested in the judiciary, the proper exercise of such power requires prior legislative action, defining such enforceable and demandable rights and determining the court with jurisdiction to hear and decide controversies or disputes arising from legal right. Courts cannot exercise judicial power when there is no applicable law. The court has no authority to entertain an action for judicial declaration of citizenship because there was no law authorizing such proceeding. Chani Tan versus Republic. An award of honors to a student by a board of teachers may not be reversed by a court where the awards are governed by no applicable law. Santiago versus Bautista. Nor may courts reverse the award of a board of judges in an oratorical contest. Felipe versus Liuterio. Jurisdiction. Section 2. The Congress shall have the power to define, prescribe, and apportion the jurisdiction of the various courts, but may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5 thereof. No law shall be passed reorganizing the judiciary when it undermines the security of tenure of its members. Definition: jurisdiction is the power and authority of the court to hear, try, and decide a case. De la Cruz versus CA. Scope: it is not only the 1. Power to determine, but the 2. Power to enforce its determination. The 3. Power to control the execution of its decision is an essential aspect of jurisdiction. Echagaray for Secretary of Justice. Role of Congress. Power: the Congress shall have the power to define, prescribe, and apportion the jurisdiction of the various courts. Limitation: Congress may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5, Article 8. No law shall be passed reorganizing the judiciary when it undermines the security of tenure of its member. The appellate jurisdiction of the Supreme Court may not be increased by law, except upon its advice and concurrence. Jurisdiction in Section 2 refers to jurisdiction over cases, jurisdiction over the subject matter. The Supreme Court. Nature: the Supreme Court is a court of law. Its primary task is to resolve and decide cases and issues presented by litigants according to law. However, it may apply equity where the court is unable to arrive at a conclusion or judgment strictly on the basis of law due to a gap, silence, obscurity, or vagueness of the law that the court can still legitimately remedy the special circumstances of the case. Section 3, Section 1 of 2010 Supreme Court Internal Rules. Concept of precedence in Supreme Court. The Chief Justice enjoys precedence over all other members of the court in all official functions. The Associate Justices shall have precedence according to the order of their appointments as officially transmitted to the Supreme Court. The rule on precedence shall be applied in the following instances: in the determination of the chairpersonship of the division, in the seating arrangement of the justices in all official functions, and in the choice of office space, facilities, equipment, transportation, and cottages. Composition. Section 4. The Supreme Court shall be composed of a Chief Justice and 14 Associate Justices. It may sit en banc or in its discretion in division of 3, 5, or 7 members. Any vacancy shall be filled within 90 days from the occurrence thereof. Composition of the Supreme Court. 15. 1 Chief Justice and 14 Associate Justices. By so fixing the number of members of the Supreme Court at 15, it seems logical to infer that no statute may validly increase or decrease it. Collegiate Court. The primary purpose of a collegiate court is precisely to provide for the most exhaustive deliberation before a conclusion is reached. Qualification. Section 7. No person shall be appointed member of the Supreme Court or any lower collegiate court unless he is a natural-born citizen of the Philippines. A member of the Supreme Court must be at least 40 years of age and must have been for 15 years or more a judge of a lower court or engaged in the practice of law in the Philippines. The Congress shall prescribe the qualification of judges of lower courts, but no person may be appointed judge thereof unless he is a citizen of the Philippines and a member of the Philippine Bar. A member of the judiciary must be a person of proven competence, integrity, probity, and independence. Qualification of a member of the Supreme Court must be a natural-born citizen, must be at least 40 years old, must have been for 15 years or more judge of a lower court or engaged in the practice of law in the Philippines, a person of proven competence, integrity, probity, and independence. Congress may not alter the qualifications of members of the Supreme Court and the constitutional qualifications of other members of the judiciary, but Congress may alter the statutory qualifications of judges and justices of lower courts. It behooves every prospective appointee to the judiciary to apprise the appointing authority of every matter bearing on his fitness for judicial office, including such circumstances as may reflect on his integrity and probity. Thus, the fact that a prospective judge failed to disclose that he had been administratively charged and dismissed from the service for grave misconduct by a former president of the Philippines was used against him. It did not matter that he had resigned from office and that the administrative case against him had become moot and academic. Similarly, before one is offered an appointment to the Supreme Court can accept it, he must correct the entry in his birth certificate that he is an alien. A member of the judiciary must be a person of proven competence, integrity, probity, and independence. Competence. In determining the competence of the applicant or recommendee for appointment, the Judicial and Bar Council shall consider his educational preparation, experience, performance, and other accomplishments of the applicant. Integrity. The Judicial and Bar Council shall take every possible step to verify the applicant's record of and reputation for honesty, integrity, incorruptibility, irreproachable conduct, and fidelity to sound moral and ethical standards. Probity and independence. Any evidence relevant to the candidate's probity and independence, such as, but not limited to, decision he has rendered if he is an incumbent member of the judiciary, or reflective of the soundness of his judgment, courage, rectitude, cold neutrality, and strength of character, shall be considered. Rule 5, Section of JBC Rules. Judicial and Bar Council. Composition. Section 8. Judicial and Bar Council is hereby created under the supervision of the Supreme Court, composed of the Chief Justice as ex officio chairman, the Secretary of Justice as a representative of the Congress and ex officio members, a representative of the integrated bar, a professor of law, a retired member of the Supreme Court, and a representative of the private sector. The regular members of the council shall be appointed by the President for a term of 4 years with the consent of the Commission on Appointments. Of the members first appointed, the representative of the integrated bar shall serve for 4 years, the professor of law for 3 years, and the retired justice for 2 years, and the representative for the private sector for 1 year. The clerk of the Supreme Court shall be the secretary ex officio to the council and shall keep a record of its proceedings. The regular member of the council shall receive such emolument as may be determined by the Supreme Court. The Supreme Court shall provide in its annual budget the appropriations for the council. The council shall have the principal function of recommending appointees to the judiciary. It may exercise such other functions and duties as the Supreme Court may assign to it. Composition of JBC. Chief Justice, ex officio chairman. Ex officio members, Secretary of Justice, Representative of Congress, regular members, term 4 years, appointed by President with the consent of CA, Representative of IBP, Professor of Law, retired member of Supreme Court, Representative of Private Sector. The Clerk of the Supreme Court shall be the Secretary ex officio of the JBC. Representative from Congress. Such representative may come from either house. In practice, the two houses now work out a way of sharing representation. A member from each comes from both houses, but each have only half a vote. Function of JBC. JBC's principal function is to recommend to the President appointees to the judiciary. It may exercise such other functions and duties as the Supreme Court may assign to it. JBC does not perform judicial or quasi-judicial functions. Rationale for creating a JBC. The Council was principally designed to eliminate politics from the appointment and judges and justices. Thus, appointments to the judiciary do not have to go through a political commission on appointments. Relationship of JBC and SC Supreme Court. The court cannot dictate on the JBC the result of its assigned task. Example, who to recommend or what standards to use to determine who to recommend. It cannot even direct the JBC on how and when to do its duty, but it can, under its power of supervision, direct the JBC to take such action or step as prescribed by law to make them perform their duties. If the duties are not being performed because of JBC's fault or inaction, or because of extraneous factors affecting performance. Note in this regard that constitutionally, the court can also assign the JBC other functions and duties, a power that suggests authority beyond what is purely supervisory. The process of preparing and submitting a list of nominees is an arduous and time-consuming task that cannot be done overnight. It is a 6-step process lined with standards requiring the JBC to attract the best available candidates, to examine and investigate them, to exhibit transparency in all its actions while ensuring that these actions conform to constitutional and statutory standards, such as the election ban on appointments, to submit the required list of nominees on time, and to ensure as well that all these acts are politically neutral. On the time element, the JBC list for the Supreme Court has to be submitted on or before the vacancy occurs, given the 90 days deadline that the appointing president is given in making the appointment. The list will be submitted not to the president as an outgoing president, nor to the election winner as an incoming president, but to the president of the Philippines, whoever he or he may be. He or she may be. If the incumbent president does not act on the JBC list within the time left in her term, the same list shall be available to the new president for him to act upon. In all this, the Supreme Court bears the burden of overseeing that the JBC's duty is done. Unerringly and with utmost dispatch, the Court cannot undertake this supervision in a manner consistent with the Constitution's expectation from the JBC unless it adopts a proactive stance within the limits of its supervisory authority. Judge Brion's concurring and dissenting opinion in De Castro versus JBC. Appointment. Section 9. The members of the Supreme Court and judges of lower court shall be appointed by the President from a list of at least 3 nominees prepared by the JBC for every vacancy. Such appointments need no confirmation. For the lower courts, the President shall issue the appointments within 90 days from the submission of the list. For every vacancy, the Judicial and Bar Council submits to the President a list of at least 3 names. The President may not appoint anybody who is not in the list. If the President is not satisfied with the list, he may ask for another list. Is that so? Why at least 3? The reason for requiring at least 3 nominees for every vacancy is to give the President enough leeway in the exercise of his discretion when he makes his appointment. If the nominee were limited to only 1, the appointment would in effect be made by the Judicial and Bar Council, with the President performing only the mathematical act of formalizing the commission. Judges may not be appointed in an acting capacity or temporary capacity. It should be noted that what the Constitution authorized the President to do is to appoint justices and judges, and not the authority to merely to designate a non-member of the Supreme Court temporarily to sit as Justice of Supreme Court. Do you know that when there is a vacancy in the Supreme Court, the remaining members of the tribunal vote and make a recommendation to the Judicial and Bar Council? Salaries. Section 10. The salary of the Chief Justice and the Associate Justices of the Supreme Court and of judges of lower court shall be fixed by law. During their continuance in office, their salary shall not be decreased. The prohibition of the diminution of salary of justices and judges during their continuance in office is intended as a protection for the independence of the judiciary. The clear intent of the Constitutional Commission was to subject the salary of the judges and justices to income tax. Nitafan versus CIR. Tenure. Section 11. The members of the Supreme Court and judges of lower court shall hold office during good behavior until they reach the age of 70 years or become incapacitated to discharge the duties of their office. The Supreme Court and Bank shall have the power of discipline judges of lower courts or order their dismissal by a vote of majority of the members who actually took part in the deliberations on the issues in the case and voted thereon. Security of tenure is essential to an independent judiciary. The Supreme Court may investigate or discipline its own members. Bar Matter to number 979. A justice was censured for failing to disclose on time his relationship to an examinee and for breach of duty and confidence. 50% of the fees due the justice as a former chairman was forfeited. In Ray, undated letter to Mr. Louis Biraogo, Justice Reyes was liable for grave misconduct for leaking a confidential internal document and was fined 500,000 and was disqualified from holding any office or employment in government. He was also suspended indefinitely from the practice of law. Removal by impeachment. The members of the Supreme Court are removable only by impeachment. They can be said to have failed to satisfy the requirement of good behavior only if they are guilty of the offenses which are constitutional grounds for impeachment. The members of the Supreme Court may be removed from office on impeachment for and conviction of 1. Culpable violation of the Constitution, 2. Treason, 3. Bribery, 4. Graft and corruption, 5. Other high crimes, c. Betrayal of public trust. A Supreme Court justice cannot be charged in a criminal case or a disbarment proceeding because the ultimate effect of either is to remove him from office and thus circumvent the provision on removal by impeachment, thus violating his security of tenure. Prohibition. Section 12. The members of the Supreme Court and of other courts established by law shall not be designated to any agency performing quasi-judicial or administrative functions. The provision merely makes explicit an application of the principles of separate of powers. Take note of the other tasks given to Supreme Court or the members of Supreme Court by the Constitution. 1. Supreme Court and banks as Presidential Electoral Tribunal. Chief Justice as presiding officer of the Impeachment Court when the President is in trial. Chief Justice as ex officio chairman of the JBC. Justices as member of electoral tribunals. Powers of Supreme Court. Section 5. The Supreme Court shall have the following powers: exercise original jurisdiction over cases affecting ambassadors, other public ministers and consuls, and over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus, review, revise, reverse, modify, or affirm on appeal or certiorari as the law of or rules of court may provide, final judgments and orders of lower courts in all cases in which the constitutionality or validity of any treaty, internal or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulations is in question. All cases involving the legality of any tax, impost, assessment, or toll, of any penalty imposed in relation thereto. All cases in which the jurisdiction of any lower court is an issue. All criminal cases in which the penalty imposed is reclusion perpetua or higher. All cases in which only an error of question of law is involved. Assign temporarily judges of lower courts to other stations as public interest may require. Such temporary assignment shall not exceed 6 months without the consent of the judge concerned. Order a change of venue or place of trial to avoid miscarriage of justice. Promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. Such rules shall provide a simplified and inexpensive procedure for the speedy disposition of cases, shall be uniform for all courts of the same grade, and shall not diminish, increase, modify substantive rights. Rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. Appoint all officials and employees of the judiciary in accordance with the civil service law. Section 6. The Supreme Court shall have administrative supervision over all courts and the personnel thereof. Section 11. The Supreme Court and bank shall have the power of discipline judges of lower courts, or order their dismissal by a vote of a majority of the members who actually took part in the deliberations on the issue in the case and voted thereon. General power, judicial power. Specific power: original jurisdiction, appellate jurisdiction, temporal assignment of judges, change of venue or place of trial, rulemaking power, appointment of court personnel, administrative supervision of courts, dismissal, removal powers. Section 5, number 1 and 2 refers to the irreducible jurisdiction of the Supreme Court, while Section 5, number 3 to 6, and Section 6 provide of auxiliary administrative powers. Other powers of the Supreme Court: jurisdiction over proclamation of martial law or suspension of the writ of habeas corpus, jurisdiction over presidential and vice presidential election contests, jurisdiction over decision, order, or ruling of the Constitutional Commission, supervision over JBC, power to punish contempt. Original jurisdiction. Section 5, number 1. The Supreme Court has original jurisdiction over cases affecting ambassadors, other public ministers, and consuls, petition for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. Note that under international law, diplomats and even consuls to a lesser extent are not subject to jurisdiction of the courts of the receiving state, save in certain cases as when immunity is waived either expressly or impliedly. In such instances, the Supreme Court can and probably should take cognizance of the litigation in view of possible international repercussions. The petitions for certiorari, mandamus, prohibition, and quo warranto are special civil actions. The questions raised in the first 3 petitions are questions of jurisdiction or grave abuse of discretion, and in 4, the title of the respondent. The petition for habeas corpus is a special proceeding. Concurrent jurisdiction. The Supreme Court has concurrent original jurisdiction with regional trial courts in cases affecting ambassadors or public ministers and consuls. The Supreme Court has concurrent original jurisdiction with the Court of Appeals in petition for certiorari, prohibition, and mandamus against the regional trial courts. The Supreme Court has concurrent original jurisdiction with the Court of Appeals and the regional trial courts in the petition for certiorari. The prohibition and mandamus against lower courts and bodies and in petitions for quo warranto and habeas corpus. Principle of judicial hierarchy. Under a judicial policy recognizing hierarchy of courts, a higher court will not entertain direct resort to it unless the redress cannot be obtained in the appropriate court. Santiago versus Vasquez. Thus, while it is true that the issuance of a writ of prohibition under Rule 65 is within the jurisdiction of the Supreme Court, a petitioner cannot seek relief from the Supreme Court where the issuance of such writ is also within the competence of the regional trial court or the Court of Appeals. A direct recourse of the Supreme Court's regional jurisdiction to issue writs should be allowed only when there are special and important reasons thereof, clearly and specifically set out in the petition. Mangajas versus Paredes. Q. What cases may be filed originally in the Supreme Court? Answer. Only petition for certiorari, prohibition, mandamus, quo warranto, habeas corpus, disciplinary proceedings against members of the judiciary and attorneys, and affecting ambassadors, other public ministers, and consuls may be filed originally in the Supreme Court. Appellate jurisdiction. Section 5, number 2. The Supreme Court has the power to review, revise, reverse, modify, or affirm on appeal or certiorari as the law or the rules of court may provide, final judgment and orders of lower courts in all cases in which the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulations is in question. All cases involving the legality of any tax, impost, assessment, or toll, or any penalty imposed in relation thereto. All cases in which the jurisdiction of any lower court is in issue. All criminal cases in which the penalty imposed is reclusion perpetua or higher. All cases in which only an error or question of law is involved. Irreducible. This appellate jurisdiction of the Supreme Court is irreducible and may not be withdrawn from it by Congress. Final judgments of lower courts. It should be noted that the appeals allowed in this section are from final judgments and decrees only of lower courts or judicial tribunals. Administrative decisions are not included. The lower courts have competence to decide constitutional questions. Section 5, number 2, letter A, provides that Supreme Court has appellate jurisdiction over final judgments and orders all cases in which the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. Review of death penalty. Section 5 requires a mandatory review by the Supreme Court of cases where the penalty imposed is reclusion perpetua, life imprisonment, or death. However, the Constitution has not prescribed an intermediate review to ensure utmost circumspection before the penalty of death, reclusion perpetua, or life imprisonment is imposed. The rule now is that such cases must be reviewed by the Court of Appeals before they are elevated to the Supreme Court. Note, however, that the rule for the review of decisions of lower courts imposing death or reclusion perpetua or life imprisonment are not the same. In case the sentence is death, there is automatic review by the Court of Appeals and ultimately by the Supreme Court. This is mandatory, and neither the accused nor the courts may waive the right of appeal. In the case of the sentence of reclusion perpetua or life imprisonment, however, although the Supreme Court has jurisdiction to review them, the review is not mandatory. Therefore, review in these latter cases may be waived and appeal may be withdrawn. In Republic v. Sandigan-Bayan, 2002, it was held that the appellate jurisdiction of the Supreme Court over decisions and final orders of the Sandigan-Bayan is limited to questions of law. A question of law exists when the doubt or controversy concerns the correct application of law or jurisprudence to a certain set of facts, or when the issue does not call for an examination of the probative value of the evidence presented, the truth or falsehood of facts being admitted. Temporary assignment of judges. Section 5, number 3. The Supreme Court has the power to assign temporarily judges of lower courts to other stations, as public interest may require. Such temporary assignment shall not exceed 6 months without the consent of the judge concerned. Rationale of the provision. The present rule bolsters the independence of the judiciary insofar as it vests the power to temporarily assign judges of inferior courts directly in the Supreme Court and no longer in the executive authorities, and conditions the validity of any such assignment in excess of 6 months upon the consent of the transferred judge. This will minimize, if not altogether eliminate, the pernicious practice of the regadon de jueces, or the transfer of judges at will to suit the motivations of the chief executive. Purpose of the transfer. Temporary assignments may be justified to arrange for judges with clogged dockets to be assisted by their less busy colleagues, or to provide for the replacement of the regular judge who may not be expected to be impartial in the decision for particular cases. Permanent transfer. Since transfer imports removal from one office and since a judge enjoys security of tenure, it cannot be effected without the consent of the judge concerned. Change of venue or place of trial. Section 5, Number 4. The Supreme Court has the power to order a change of venue or place of trial to avoid a miscarriage of justice. This power is deemed to be an incidental and inherent power of the court. Rulemaking power. Power to promulgate rules. The Supreme Court has the power to promulgate rules concerning 1. The protection and enforcement of constitutional rights. 2. Pleading, practice, and procedure in all courts. 3. The admission to the practice of law. 4. The integrated bar. 5. Legal assistance to the underprivileged. Section 5, Number 5. Limits on Supreme Court's rule-making power. Such rules shall provide a simplified and inexpensive procedure for the speedy disposition of cases. 2. They shall be uniform for all courts of the same grade. 3. They shall not diminish, increase, modify substantive rights. Rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. Nature and function of rule-making power. For a more independent judiciary, the authority to promulgate rules concerning pleading, practice, and admission to the practice of law is a traditional power of the Supreme Court. The grant of this authority, coupled with the authority to integrate the bar, to have administrative supervision over all courts, in effect places in the hands of Supreme Court the totality of the administration of justice, and thus makes for a more independent judiciary. Enhances the capacity to render justice. It also enhances the court's capacity to render justice, especially since, as the Supreme Court has had occasion to say, it includes the inherent authority to suspend rules when the requirement of justice demand. Moreover, since it is the Supreme Court that rule-making authority has been given, rules promulgated by special courts and quasi-judicial bodies are effective unless disapproved by the Supreme Court. Test to determine whether the rules diminish, increase, or modify substantive rights. 1. If the rule takes away a vested right, it is a substantive right. If the rule creates a right, it may be substantive matter. If it operates as a means of implementing an existing right, then the rule deals merely with procedure. Fabian versus Desierto. Illustrative cases where the rule merely deals with procedure. Maniago versus CA, 1996. The rule that unless a reservation to file a separate civil action is reserved, the civil case is deemed filed with a criminal case is not about substantive rights. Whether the two actions must be tried in a single proceeding is a matter of procedure. Fabian versus Desierto. The transfer of the Supreme Court of pending cases involving a review of decision of the Office of the Ombudsman in administrative actions to the Court of Appeals is merely procedural. This is because it is not the right to appeal of an aggrieved party which is affected by law. The right has been preserved. Only the procedure by which the appeal is to be made or decided has been changed. People versus Lacson. This is quite confusing because of the dates. Facts. Respondent was charged with multiple murder. He filed a motion with the trial court for judicial determination of probable cause. On March 29, 1999, the trial court dismissed the cases provisionally. On December 1, 2000, the revised rules on criminal procedure took effect. Section 8 of Rules 1117 allowed the revival of the case, which was provisionally dismissed only within 2 years. On June 6, 2001, the criminal cases against respondent were refiled. Respondent argued that the refiling of the cases was barred. The prosecution argued that under Article 90 of the Revised Penal Code, it had 20 years to prosecute. Respondent held, is the rule merely procedural? Maybe that's the issue. Yes, the rule is merely procedural. Section 8, Rule 117 is not a statute of limitations. The 2-year bar under the rule does not reduce the periods under Article 90 of the Revised Penal Code. It is but a limitation of the right of the state to revive a criminal case against the accused after the case had been filed but subsequently provisionally dismissed with the express consent of the accused. Upon the lapse of the period under the new rule, the state is presumed to have abandoned or waived its right to revive the case. The prescription periods under the Revised Penal Code are not diminished. Is the refiling of cases barred in this case? No. A procedural law may not be applied retroactively, if to do so would work injustice or would involve intricate problems of due process. The time bar of 2 years under the new rule should not be applied retroactively against the state. If the time bar were to be applied retroactively so as to commence to run on March 31, 1999, then the prosecutor received his copy of the resolution dismissing the cases instead of giving the state 2 years to revive the provisionally dismissed cases. The state would have considerably less than 2 years to do so. The period before December 1, 2000 should be excluded in the computation of the 2-year period because the rule prescribing it was not yet in effect at that time and the state could not be expected to comply with it. Illustrative cases where the rule deals with substantive matter. PNB versus Asuncion. Facts. Petitioner filed a collection case against several solidary debtors. One of them died during the pendency of the case. The court dismissed the case against all the defendants on the ground that the petitioner should file a claim in the estate proceedings. Petitioner argued that the dismissal should be confined to the defendant who died. Held, Article 12:16 of the Civil Code gives the creditor the right to proceed against any one of the solidary debtors or some or all of them simultaneously. Hence, in case of death of one of them, the creditor may proceed against the surviving debtors. The rules of court cannot be interpreted to mean that the creditor has no choice but to file a claim in the estate of the deceased. Such construction will result in the diminution of the substantive rights granted by the Civil Code. Santero versus CFI. Facts. During the pendency of the proceeding for the settlement of the estate of the deceased, respondents who were children of the deceased filed a motion asking for an allowance for their support. Petitioners who were children of the deceased with another woman opposed on the grounds that petitioners were already of majority age and under Section 3 of Rule 83, the allowance could be granted only to minor children. Held, Article 188 of the Civil Code grants children the right to support even beyond the age of majority. Hence, the respondent were entitled to the allowance. Since the right to support granted by the Civil Code is substantive, it cannot be impaired by Section 3, Rule 83 of the Rules of Court. Damasco versus Lucky. Facts. Petitioner was charged with grave threats. The trial court convicted him of light threats. Petitioner moved for reconsideration because the crime of which he was convicted had already prescribed when the information was held, while an accused who fails to move to quash is deemed to waive all objection, which are grounds to quash. This rule cannot apply to prescription. Prescription extinguishes criminal liability. To apply the said rule will contravene Article 89 of the Revised Penal Code, which is substantive. The rules promulgated by the Supreme Court must not diminish, increase, or modify substantive rights. Saldivia versus Reyes. On May 30, 1990, a complaint was filed with the provincial prosecutor against petitioner for violating an ordinance by quarrying without a mayor's permit. The information was filed in court on October 2, 1990. Petitioner moved to quash on the ground that under Article 3326, violations of municipal ordinances prescribe in 2 months, and the prescriptive period is suspended only upon the institution of judicial proceedings. The prosecution argued that under Section 1, Rule 110 of the Rules on Criminal Procedure, the filing of a case for preliminary investigation interrupts the prescriptive period held. If there is a conflict between Act number 3326 and Rule 110 of the Rules on Criminal Procedure, the former must prevail. Prescription in criminal cases is a substantive right. Illustrative case where retroactive application of a ruling will affect substantive right. LBP versus De Leon. Facts. The Supreme Court ruled that in accordance with Section 60 of the Comprehensive Agrarian Reform Law, appeals from the special agrarian courts should be made by filing a petition for review instead of merely filing a notice of appeal. Petitioner filed a motion for reconsideration in which it prayed that the ruling be applied prospectively. Held. Before the case reached the Supreme Court, petitioner had no authoritative guideline on how to appeal decision of special agrarian courts in the light of seemingly conflicting provisions of Section 60 and 61 of the Comprehensive Agrarian Reform Law. Because Section 61 provided that review shall be governed by the rules of court, the Court of Appeals had rendered conflicting decisions on this precise issue. Hence, the decision of the Supreme Court should be applied prospectively because it affects substantive right. If the ruling is given retroactive application, it will prejudice the right of appeal of petitioner because its pending appeals in the Court of Appeals will be dismissed on a mere technicality, thereby sacrificing their substantial merits. Power to make rules. Writ of amparo. The rules on the writ of amparo is promulgated by the court based on its power to promulgate rules for the protection and enforcement of constitutional rights. In light of the prevalence of extralegal killing and enforced disappearances, the Supreme Court resolved to exercise for the first time its power to promulgate rules to protect our people's constitutional rights. Writ of amparo. Etymology. Amparo comes from Spanish verb amparar, meaning to protect. Nature. A writ to protect right of life, liberty, and security of persons. Section 1 of the Rule on the Writ of Amparo. The petition for a writ of amparo is a remedy available for any person whose right to life, liberty, and security is violated or threatened with violation by unlawful act or omission of a public official or employee or a private individual or entity. The writ shall cover extralegal killings and enforced disappearances or threats thereof. Note that not all constitutional rights are covered by this rule, only right to life, liberty, and security. Writ of habeas data. The writ of habeas data is a remedy available to any person whose right to privacy in life, liberty, or security is violated or threatened by an unlawful act or omission of a public official or employee, or of a private individual or entity engaged in the gathering, collecting, or storing of data or information regarding the person, family, home, and correspondence on the aggrieved party. Writ of Kalikasan. The writ is a remedy available to a natural or juridical person, entity authorized by law, people's organization, non-governmental organization, or any public interest group accredited by or registered with any government agency on behalf of persons whose constitutional rights to a balanced and healthful ecology is violated or threatened with violation by an unlawful act or omission of a public official or employee or private individual or entity involving environmental damage of such magnitude as to prejudice the life, health, or property of inhabitants in two or more cities or provinces.